All right, good afternoon. This is a video lecture for Chapter 2 of America's Courts. Um, so let's get started. I hope you've already printed out your PowerPoint. I would highly suggest printing it out and then using the margins of that PowerPoint to either highlight areas that we discuss and are rather important, and or to jot down notes of what's being presented in this lecture. So we're going to be discussing federal courts, all the way from organization all the way down to different types of courts within the federal court system, from district courts to the specialized courts again, and then to the Supreme Court of the United States, which is the highest appellate court. The founding fathers, with regard to the courts, were divided whether or not there should be federal courts besides the state Supreme Court of the United States. And that was because originally, again, the founding fathers decided that having federal courts would be very intrusive into the lives of the people. And you have to remember that when the colonists decided they wanted to proclaim their independence, one of the reasons why they did it is because they wanted to minimize government intervention. So there was kind of a little bit of a push and pull with regard to the idea of having more than the Supreme Court of the United States. And ultimately, we obviously decided to do that. The United States employs a dual court system, which includes federal courts and separate court systems within each of the states. So in some instances, both federal and state courts maintain jurisdiction in certain types of criminal activity. You can see that in drug trafficking across state lines, civil rights violations. And this type of maintaining of jurisdiction in both by the federal government and the state government is called concurrent jurisdiction. And that means both court systems, federal and state, maintain and they share the same judicial powers, same jurisdiction over those types of crimes. Okay, so you'll see that again, concurrent jurisdiction. Jurisdiction essentially is the power of the state to decide on a dispute. And there are different types of jurisdictions, four primary types. Geographic, that's pretty self-explanatory. It's based off of geography. Subject matter jurisdiction, the idea there would be such as civil courts versus criminal courts, or juvenile courts, that kind of stuff. So we're talking about areas where the court focuses on one type of jurisprudence, right? Personal jurisdiction, and then hierarchical jurisdiction, and that rounds out the four. So geographical, subject matter, personal jurisdiction, and hierarchical jurisdiction. And you will need to know those, so be aware of them. So we talked about geographical jurisdiction. So that's also known, it's territorial. And they're talking about the area where the court maintains, the actual physical area the court maintains power to enforce the law. Along with that, the idea of venue comes in, and that's the location where the court has geographical jurisdiction and actually hears the case. So the federal court system, there are 12 regional circuit courts, or circuits rather, that comprise 94 federal courts, which also include the appellate courts. All right, so that's a geographical jurisdiction. Subject matter jurisdiction, we talked about that, refers to the court to hear a specific type of case. Traffic court, juvenile court, we talked about that. Personal jurisdiction refers to, is derived from the Latin in personam, which refers to the court's power over individual persons or corporations. And an example there would be juvenile court, right? So juvenile court refers to the power the court has over one type of person, which would be juveniles. Hierarchical jurisdiction refers to the differences in court functions and responsibilities. So, and we talked earlier about those. We talked about the trial courts, major trial court and lower court, and then appellate jurisdiction, which is a step above what the trial court has. So original jurisdiction would be in the hierarchical would be the lower end, and that would be trial courts, which have the authority to try a case, and then a step above that would be appellate jurisdiction, which is the appeals court, and there are even steps above the appellate jurisdiction or appeals court. So you have in the federal government, you have your appellate court, and then you have your Supreme Court of the United States. Okay, so the history of federal courts. Two landmark documents establish federal courts. That would be Article 3 of the Constitution and the Judiciary Act of 1789. And that Judiciary Act of 1789 was established during the Constitutional Convention in 1787, and that was a resolution that was unanimously adopted that established that there was going to be a national judiciary. So, in other words, we are going to have a national, or rather a federal court. So you'll need to know those two. Article 3 of the United States Constitution is one of the documents that establishes the power for having a federal court, and the Judiciary Act of 1789. All right, and Article 3 establishes the power of the United States, judicial power of the United States, saying that that power shall be vested in one Supreme Court, and inferior courts from time to time be established by the United States Constitution. So primarily the Supreme Court and some lower courts, which we have now as the appellate courts. The Judiciary Act of 1789 laid the foundation for the interior federal courts to be established. That was the idea that all the other trial courts and appellate courts were established. This act mandated geographical jurisdiction along state lines for federal district courts. It also ensured that district judges will be given would be residents of their district. In other words, if you were a district judge from Texas, that you had to reside in Texas, and you had to be nominated by the President of the United States, and the lower federal courts would only have limited jurisdiction. Court of Appeals Act of 1891, that act created the Circuit Court of Appeals, which released the Supreme Court of the United States from hearing a lot of the minor appeal cases, and essentially allowed the Supreme Court to act as the court of last resort, and to allow that court to be what's the word I want to use? Allow them to have say in whether or not they were going to actually hear a case. So they were a discretionary court, not necessarily one that was mandated. So that the Supreme Court of the United States has discretion as to what cases they're going to hear. In 1925, Congress passed the Judges Bill, which gave the Supreme Court more control over its docket, and that's kind of, again, where we came into the idea that the Supreme Court wasn't going to be mandated to hear cases, so it gave them jurisdiction. And then 1984, Sentencing Commission was established and charged with developing sentencing guidelines for federal courts. In 88, Congress gave mandatory appeals to the High Court. And then in 2001, the Patriot Act was established, which is still in effect now, to gather domestic terrorism intelligence with less court oversight and closing some court proceedings to the public. One of the courts that was established was the FISA court, to allow the judges to provide warrants with less information. All right. U.S. district courts. So remember, we talked about district courts. These are the equivalent of trial courts. They created 94 U.S. district courts. 89 of them are located within the 50 states. There's also a district court in the District of Columbia, Washington, D.C., and for territorial districts in Puerto Rico, the Virgin Islands, and the Northern Mariana Islands. Congress created 677 district court judgeships for the 94 district courts. So in those 94 district courts, there are 677 judgeships, or 677 judges. There is at least one federal district court in each state to ensure that no district court crosses state lines. However, again, because we have 94 district courts, we know that we have more district courts than we have states. Some states have more than one federal district court, and that's based off of geography, obviously, or population, based off of the court's ability to hear that many cases. So some states may have more than one district court. District courts are trial courts, and they hear cases based on violations of federal criminal law. The U.S. District Attorney files roughly 80,000 criminal cases, and they're primarily for drug violations, embezzlement, and fraud in federal district courts. And the Supreme Court hears about 7,000 to 8,500 cases a year. Federal Appeals Court hear about 50,000 plus cases a year, and federal district courts hear about 300 to 350,000 cases a year. So if you look at 300 to 350,000 cases by 677 court judgeships, you can see that the processing of these cases, they process quite a few of them. So it's not an easy job. One of the mechanisms we talked about earlier was through plea bargaining. That's one of the major mechanisms of trying to move these cases quickly through the courtroom process. Workload of district judges has been reduced by adding approximately 350 adjunct bankruptcy judges to hear cases relating to bankruptcy, and that's one of the primary responsibilities of district court judges. At one point, they reached 1.78 million petitions. However, that number did drop. I'm sure it increased substantially in 2008, 2009 when we had that big drop in our housing market. So a number of people filed bankruptcy during that period of time because they lost their property. And so we had quite a few petitions, I'm sure. And then again, we started to recover. And right now, I'm sure again, because we are moving up into a really high unemployment rate, that we can see bankruptcy filings increasing again. So that would not surprise me. Excuse me. Federal questions. So diversity of citizenship. You'll need to know this. Are cases that involve suits between citizens of different states, or between a citizen and a foreign country or foreign citizen. And pursuant to the Supreme Court decision of Erie Railroad Company v. Tompkins, and that was in 1938, federal courts must apply state law when adjudicating suits under the diversity of citizen jurisdiction. So, and specifically state law with regard to the two plaintiffs. Okay, so you'll probably see that again. Erie Railroad Company v. Tompkins. Article 3 provides federal court that may be given jurisdiction over cases in law and equity arising under the Constitution. The laws of the United States and treaties made or shall be made under its authority, and that's called a federal question, which in essence is subject matter jurisdiction for the federal district court to hear a case in relation to violations of the Constitution or federal law. So Article 3 essentially provides for the federal question and allows the federal district court to hear case violations in relation to the Constitution. But we did talk earlier that state courts may have concurrent jurisdiction with the federal courts and hearing some of these cases, to include cases that would be like civil violations or violations of the Constitution. Types of federal question jurisdictions include suits between states. So obviously we're not going to have states dealing with suits between states, so that moves to the federal courts. Also involving high-ranking public officials or foreign ambassadors, patent copyrights, trademark cases, antitrust cases, which are designed to protect free trade and commerce, which is the province of the federal government. We talked about, and you can see that through the highway system, right? So the federal government highway system, the interstate system, like Interstate 10, falls under the federal government purview versus the state government purview. And also securities and banking regulations fall under federal government jurisdiction. But again, they could fall under state government jurisdiction as well. So there is a lot of overlap, folks. There's a lot of overlap with regard to case law. All right, discrimination law, civil rights, and prisoner petition. So federal law, codified in the Bill of Rights, prohibits discrimination on the basis of race, religion, sex, national origin in the areas of employment, welfare, housing, voting, and a number of other rights and responsibilities that we have as citizens. There are some exceptions to the rule, like legitimate occupational qualifications that are related to job performance. That would be akin to a police officer. So they do have, like, some police departments have height requirements or limitations. So you can't be over a certain height because there is an issue with regard to safety if you're driving a vehicle, that kind of stuff. So they do have, or if you're paraplegic, you probably could not be a peace officer. So there are some legitimate occupational qualifications that that prevent some people from getting the job. For the most part, the Bill of Rights prohibits those discriminations based off of areas that we generally don't have any control of. We can't control our race. We can't control our sex. We can't control where we're from or what our ethnicity is. And the Bill of Rights prohibits the discrimination of those things that we can't control as human beings. Inmates in federal, state, and local detention facilities maintain certain rights also. The hands-off doctrine was essentially put to rest, and so the Supreme Court made decision that under the idea of the evolving standards of decency, that prisons and jails had to evolve based off of the idea that our society evolves. So as technology increases and gets more mainstream, so should the access to those technologies in prisons and jails and the way we treat our prisoners. So some of these rights prisoners are permitted to file civil lawsuits, also known as prisoner petitions. And there are 4 primary types. You will see these again. Habeas corpus, or writs of habeas corpus, motions to vacate a sentence, a mandamus petition, and a Section 1930 and Bivens civil right actions. So we'll kind of go through each one of those. So habeas corpus cases are those where the inmate challenges their convictions by arguing that the trial was constitutionally defective. Essentially, that either their incarceration or the trial is in violation of, or rather, the trial or their incarceration was constitutionally was in violation of the Constitution. So motions to vacate allow federal prisoners to try to get a new sentence try to get their sentence set aside because the sentence was imposed contrary to what law says. So not so much the trial itself, but the actual sentencing portion was incorrect, and that's their claim with regard to that type of lawsuit or that type of petition. A mandamus petition seeks a court order to compel either the public entity, the actual jail, prison, or the official to do something that is owed to an inmate as a matter of constitutional or statutory right. That would be akin to a prisoner submitting a request for mental health treatment that they believe is not being provided by the institution as required under law. So that would fall under a mandamus petition. And then Section 1983 Bivens civil right actions allow inmates to bring suit to those who act under the color of authority where an inmate was deprived of constitutional rights. So that would be akin to an officer acting outside of his color of authority, either in the use of force with regard to, like, if you were a correctional officer and slammed an inmate up against the wall, even though that inmate was cuffed up. That would have been unnecessary force, and they could bring suit to you with regard to being deprived of their right under the Constitution, deprived of the right to be free of cruel and unusual punishment. So those four: habeas corpus, motions to vacate, mandamus, Section 1983, or Bivens civil action or civil rights actions are the four primary prisoner petitions. So that's where we learned that again, even though they're in prison, doesn't necessarily mean that they don't have the rights under certain rights under the Bill of Rights. Some of these are curtailed, right? We do have inmates do have curtailed rights, so they don't have the right to assembly, right? We have the peaceful right to assembly as citizens, but when they're in prison, because of safety concerns within the department, they don't have the right to assemble. Okay, the United States Supreme Court, also known as the Court of Last Resort in the federal court system, they're the ones that know there is no higher appeal. Okay, so if you have a state court case and you go through the appeal process all the way up to the state Supreme Court, and then you decide you want to go forward with the federal appellate system, you go through the federal appellate system. After the federal appeals court, which is the Supreme Court of the United States, hears that case, it cannot go any further. So the federal appeals court is the court of last resort, and no other hearing on federal appeal will be heard by any other federal appeals court or state appeals court, to include a state Supreme Court. So state Supreme Courts are lower courts in relation to authority. Okay, the Constitution grants Supreme Court original jurisdiction, which allows it to act as a trial court in some cases. The appellate jurisdiction of the Supreme Court is also discretionary rather than mandatory. We talked a little bit about that. So they have the ability to decide whether or not they're going to hear a case or not hear a case. And that's under a writ of certiorari. You will hear that or see that again, which is an order by the Supreme Court to a lower court to send its case records to the Supreme Court to make a determination if a case has been or the law has been correctly applied and the case is valid. So that's when they look to make a decision if they're going to go forward with hearing that appeal. The state Supreme Court, or rather the federal Supreme Court, Supreme Court of the United States, a vote of 4 or more Supreme Court judges is required to grant certiorari, to review a case, and that's referred to as a rule of 4. You will see that again. And under 28 U.S.C. 42, each of the 13 federal circuit courts is assigned one Supreme Court justice who serves as a circuit justice and then considers certain appeals like emergency requests from his or her assigned circuit while other aspects of the case are still pending. The Chief Justice of the United States is responsible for allotting circuit justices in vacation. So if they're on vacation, that the Chief Justice basically fills in that spot. Okay, specialized federal courts, while district, trial, and appeals courts, also known as constitutional courts, are established under Article 3. Article 1 establishes specialized courts known as legislative courts. So we learned Article 3 establishes district, trial, and appeals. Article 1 establishes specialized courts, and we talked a little bit about those earlier on in the chapter. So a specialized court was designed for the purpose of administering specific congressional statutes such as taxes or patents. Specialized courts have two major distinctions from constitutional courts. You'll see this again. Judges assigned to specialized courts are full-time and are appointed unlike appointed for a specific term in office, unlike Article 3 judges who enjoy salary protections. Article 1 judges don't get that as well. So these judges are full-time and are appointed for a specific term, and they don't enjoy salary protections, unlike their Article 3 judges who do, and those would be district court and appeals court judges. Specialized courts are overwhelmingly civil in their orientation, which means that most of these courts are like tax courts, patent courts, that kind of court. We talked about earlier on. We talked about bankruptcy court. So those are all civil. However, they do have criminal courts within the specialized courts under Article 1. There are 3 primary ones, and you'll need to know these. So military courts, they fall under, obviously, the United States military, and their law falls under UCMJ, the Uniform Code of Military Justice. You have the Foreign Intelligence Surveillance Act, which is FISA, the FISA courts under the Patriot Act. FISA courts issue warrants, and they do deal with criminal acts. And then again, immigration courts, which they also hear criminal matters such as illegal immigration and whether or not to deport or not to deport. So those are the specialized courts under Article 1. And again, remember, there are 3. They're primarily civil in their orientation, but there are 3 of them that do hear criminal matters. Okay, specialized criminal courts. So we talked about specialized criminal courts, and we're going to focus a little bit more on the specialized criminal courts, which again deal with criminal matters. So in 1950, the United States Congress adopted the Uniform Code of Military Justice, UCMJ, and the U.S. Court of Appeals for Armed Forces. And the intent was to extend rights to military personnel and civilian employees. There are some differences in how military justice works as opposed to its civil counterpart, or rather civilian counterparts. Proceedings are open to military society, but generally not open to civilian society. The burden of proof is less demanding. So remember, we have a burden of proof beyond a reasonable doubt. Their burden of proof is probable cause. 3- and 5-person juries are used. And obviously, jurors are military personnel. 2/3 majority is sufficient to convict, whereas in ours, we have to have either full consensus of the jury or a majority. So it's a lesser standard. And convictions are automatically appealed to a higher military court versus ours, which have to be submitted by the appellate or the convicted person. All right, so that's for military courts. Foreign Intelligence Surveillance Court, known also as a FISA court, has authority over electronic surveillance of foreign intelligence agents. It was created by the Foreign Intelligence Surveillance Act, the FISA Act, under the Patriot Act. And so what they're looking at here is they're looking at essentially warrants and issuing warrants to federal agents, either FBI or CIA or any other federal agents, to conduct surveillance, wiretap, or what they call pen and trap cases, or pen and trap searches. They get authorization to conduct those type of searches through the FISA courts. And the last one is the immigration courts. And research estimates about 11 million people are illegal immigrants in the United States, and about a little under 300,000 people are that those illegal immigrants are brought into criminal matters. So the immigration courts resolve, or they deal with, about 262,000 criminal matters in the United States. Approximately 170,000 of these are concerned with either deportation or removals from the United States. So because illegal immigration is considered a crime, that's the reason why they are also immigration courts are also considered criminal courts. Okay, so again, specialized criminal courts. You have military, FISA, and immigration courts. All right, federal judicial administration. So we know through the courts that the administration of a court also is kind of separate away from the courtroom process. Administrative Office Act of 1939 expanded the responsibility of judicial conferences, created the Administrative Office of U.S. Courts, established a Judicial Council. These agencies, along with the Office of the Chief Justice, Federal Judicial Center, and the U.S. Sentencing Commission, are the main offices involved in administering federal courts, and so essentially making sure that the courts run the way they're supposed to. So the Office of the Chief Justice maintains authority over the entire federal judicial system. So you'll need to know that. Office of the Chief Justice maintains authority over the entire federal judicial system. The Judicial Conference is the administrative policy making organization of the federal judicial system, and it's responsible for drafting amendments that essentially rules that govern proceedings in federal court. So remember, we talked about courts having rules that they have to go by. The Judicial Conference is the responsible agency for drafting those rules. Administrative Office of the U.S. Court is responsible for implementing policies established by the Judicial Conference. So the Judicial Conference is the one who sets the rules. The Administrative Office is the one who implements those rules via policy. Federal Judicial Center conducts research and training in the federal judiciary personnel and judges. And the Federal Judicial Council, or the Judicial Council, also referred to as the Circuit Council, is the administrative unit of the Federal Circuit, which includes both district and appellate courts within that circuit. And the last one we talked about was the U.S. Sentencing Commission, which is an independent agency of the judicial branch consisting of members that develop sentencing guidelines and evaluate the effects of sentencing guidelines in the federal judicial system. So the U.S. Sentencing Commission also supervises not just the courts, but federal probation officers. All right. So those, all of these branches here have different responsibilities with regard to the administration of the federal courts. Okay, caseloads in federal court. So in the last 50 years, district court filings have increased substantially, more than sixfold, and appeal cases have increased more than tenfold. So 10 times in the appeal cases, 6 times in trial courts. There are two primary thoughts behind trying to reduce the federal court caseload, and so you'll need to know these two different types: increasing the number of federal judges, and or reducing federal jurisdiction. So both of these two mechanisms are the two mechanisms. They're thoughts behind reducing federal court caseload. So increasing the judges and or reducing federal jurisdiction. So only Congress can authorize additional judgeships. However, given the partisan nature of Congress, it's not likely that additional judgeships will be created. And while adding additional judgeships will reduce the caseload accounts, it'll also require more tax dollars, right? So more judges we have, the more tax dollars we're going to wind up needing to support that. And you have to remember, every judgeship is going to require additional support staff as well. So according to a report by the Federal Court Study Committee, expanding the federal court jurisdiction by Congress was the main reason for the extraordinarily high federal court caseloads. So kind of the idea of if you build it, you'll fill it. And that kind of goes to like for people who have homes. So if you move from 1,100 square foot two-bedroom apartment to a 1,700 square foot house to a 2,500 square foot house, when you think, oh my gosh, I got all this room, eventually you're going to fill that room up. And that's much what happens with regard to, or the idea that the federal court study committee found was that if we put more judges out there, we're also going to wind up getting more caseload, a higher caseload. However, reducing the federal jurisdiction will refer many cases back to state courts, thereby inundating them. So they'll have. I mean, if we lose, if we say, we're going to take away federal jurisdiction, then just because we've removed federal jurisdiction doesn't necessarily mean the crime disappears. It just means it gets shifted, and we've seen that play out in our own, the smaller scale criminal justice system with regard to our incarceration. So before Proposition 47 and AB 109, the California Department of Corrections maintained jurisdiction of parolees. Parolees, when they violated the parole, went back to state prison to serve their parole revocation period. By changing that and saying, well, we wanted to reduce our prison populations, it didn't necessarily mean that we weren't going to be sanctioning parolees who violated their parole. It just meant that we were going to be shifting the responsibility from the state prisons to county jails, because when a parolee violates the parole, that responsibility is shifted to county jails. And much like what happens here, if we reduce or we take away a federal jurisdiction, those laws are still in the books. And again, remember, we talked about state law and federal law sometimes overlap, and they have concurrent jurisdiction. If we remove the federal oversight, federal courts for that, then that jurisdiction will basically fall directly to the states, and we could overload the state courts. So the federal courts do have a little bit of a balancing act that they have to bear in mind with regard to both of these two ideas of reducing federal court caseload. So again, if we add more judges, we'll talk about filling up the House. More judges. We're thinking, we're reducing caseloads, but inevitably those caseloads will increase. And then if we reduce jurisdiction, that jurisdiction is going to wind up moving over to another party, and generally that would be the state courts. So we have to be cognizant of that. All right. Consequences of federal involvement. Crime has always been a concern, right? We talk about how crime has the ebb and flow. We talked about the pendulum swinging from the rehabilitative part of crime over back to the crime control aspect, where there's consequences. In an effort to address some of this, because like I said, people, the idea of how crime is addressed and how laws are passed basically move with the ebb and flow of the will of the people. So when there is something that happens, and in the case that's going on right now with the George Floyd incident, the George Floyd incident is making people more cognizant, and they're pushing to have laws that restrain government with regard to the policing aspect, right? So the will of the people is what kind of moves the ebb and flow of that pendulum from the rehabilitative component over to the crime control component. Congress and the President of the United States, specifically for the federal government, are primarily responsible for passing laws, making many crimes already codified by state law also crimes in federal law. So, and the primary example would be like drug law, right? So much of new federal law allows federal governments more reach into the criminal justice system, specifically the state criminal justice system. And a lot of this is brought about by symbolic policies in the form of PACs, or political action committees. And again, we're seeing some of this movement now with the George Floyd incident, but some of the older ones, some of these older laws were brought about by these political action committees like the ACLU, or MAD, Mothers Against Drunk Drivers, so some of these drunk driving laws, National Organization for Women, and a number of other, Megan's Law. So when people as a whole start seeing what they perceive as holes in the law, they try to plug these holes by forming these groups that have political clout, pushing the legislature and or the executive branch into passing laws that increase the scope of government. Honestly, some people may agree with that. Some people may disagree with it, depending on the circumstance. But one thing's for sure: it does happen, and sometimes not all for the better. Most Americans, if you were to do a survey, most Americans want safer communities. They want an active law enforcement. They want to see. I mean, when for the most part, I'm saying not in all places, but for the most part, when you see law enforcement driving on the streets, people feel safer. Especially, I mean, it's like how many of you have seen cops parked by elementary schools or junior high schools during class coming out or classes going, or not classes, but school starting or school ending. Most Americans want to see that. However, in the same breath, a lot of Americans don't want to, myself included, don't want to endure the cost it has, the cost of making sure these things happen. So we're wanting to allocate more and take from other areas. So we don't want to endure local and state tax increases to fund these services. And so that's kind of where the federal government comes in, because federal government's huge, right? They have the ability to take taxes from multiple arenas. We have income tax, we have import taxes, we have a number of different tax mechanisms within the federal government to get funding. And so the low level mayor or whatever in some of these state or city governments will look to the federal government to retrieve money for policing, to expand the policing arm in their communities without pulling more taxes or incorporating more taxes to the local communities to fund those services. Okay, that's an overview of the federal court system. Again, if there's any questions, issues, comments, or concerns, please feel free to email me or give me a call / text. I'll be more than happy to help you through it. And we will see you again on Chapter 3. Thanks so much.